that tradition forward.
So how do you respond to the other point that the government makes, the thrust of it being that the court has ordered this person to serve a, let's say, 3-year period of supervised release, and they didn't do so? Why should they get the benefit of running away or absconding and not having to comply with the court's order?
Well, in some way they just shouldn't, because at the revocation hearing, the judge is empowered to rewind the clock and require the person to start all over again. So we think there's an alignment between how abscondment is handled and other types of violations.
You mean that you envision Congress saying for the absconder, the revocation remedy is what we are imposing here?
That's exactly right, and that's how it works with other types of violations. Like, it's true that part of the essence of supervised release is supervision, but part of the essence of supervised release is also complying with the law. And yet, if a person is in a conspiracy, say for 1 year during the supervised release period, that's obviously plainly contrary to the spirit and the letter of supervised release, but the government does not claim that that stops the clock for the year. Instead, what happens is a warrant issues, the person comes to the sentencing court, and then supervised release is revoked, the person goes back to federal prison, and then back on supervised release. And so effectively, the person is stripped of credit for that year, but it's done through the mechanism of revocation. And all we're saying in this case is that the same thing should happen to abscondment, which after all is just a different type of violation of the conditions of supervised release.